Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law. Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Annemarie Bridy, Alan G. Shepard Professor of Law at the University of Idaho College of Law. We will discuss her article, Fearless Girl Meets Charging Bull, Copyright and the Regulation of Intertextuality, which is published in the UC Irvine Law Review. So welcome to the podcast, Annemarie.
Thanks, Brian. It's good to be here.
Yeah, so I really enjoyed reading this paper because it picked up on a sort of weird quasi-copyright controversy that was swirling around on the internet for a while. But I was wondering if, for people who aren't familiar with the controversy, you could give them a little bit of background so they understand better the context of the conversation that we have. So, Charging Bull, the sculpture, is pretty well-known, iconic sculpture in Lower Manhattan. But maybe you could talk a little bit about the artist who made it and how it got installed.
Sure. So Charging Bull made its debut in Manhattan in 1989. This sculptor is an Italian sculptor named Arturo Di Modica, who actually installed it under cover of darkness in front of the New York Stock Exchange and without any permission from either the exchange or the city, which makes his criticism of Fearless Girl kind of interesting because his outrage was that, the sculpture showed up in front of his sculpture without anybody's permission. So he created Charging Bull in the wake of the stock market crash of 1989. And he said the reason he created it was as a symbol of hope for the economic future of the United States. And, people have mentioned the fact that it resembles the Merrill Lynch bull trademark. And so it has become associated with capitalism and the stock market, and sort of economic prosperity, which was how he intended the sculpture to be perceived by the public.
Cool. And what about Fearless Girl? Like, who made that and how did it come to be installed in close proximity to Charging Bull?
So Fearless Girl came onto the scene on the day after International Women's Day, or on International Women's Day, I can't remember which one, in March of 2017. And it was part of a kind of guerrilla advertising campaign undertaken by State Street Global Advisors in connection with the promotion of one of its exchange-traded funds, right? So it was I can't remember the name of the fund, but the fund was set up basically to invest in companies that have good board diversity and that have a higher than typical percentage of women on their boards. And so the idea was that Fearless Girl, which was sculpted by a sculptor named Christine Visbal, and the whole campaign was done in connection with the McCann advertising company. It was going to be there for 1 week and was just sort of intended to drive a dialogue around issues of female inclusion in corporate governance in Fortune 500 companies. So Fearless Girl actually did have a permit, or State Street did have a permit to install Fearless Girl where they did. But as soon as Di Modica saw the sculpture there, he decided he didn't like it and that he was going to try to use copyright law to get Fearless Girl removed from her confrontational position in relation to his work.
Right. So how about that? I mean, just as a doctrinal matter, do you think that Di Modica has a viable copyright or kind of para-copyright claim? And if not, why not?
So I don't. And I should say, actually, that the entire controversy, such as it was, is now moot because Fearless Girl was moved at the end of November of 2018 to a site near the New York Stock Exchange. So, the entire episode remains incredibly interesting to me as a sort of exploration of the limits of U.S. copyright law. And it's interesting comparatively in terms of how U.S. copyright law differs from EU copyright law, especially when it comes to moral rights. But it's just kind of funny that now Demotica has gotten what he wants, even though copyright law was not what ultimately gave it to him. So in terms of the copyright claims, he brought two claims. He brought some trademark claims, but those aren't that interesting to me. He brought copyright claims under VARA, the Visual Artists' Rights Act, and he also alleged a violation of his derivative work right under Section 106 of the Copyright Act. So I can talk first, I guess, about the moral rights claim.
Sure.
And I guess before I talk about that, it might be helpful to talk a little bit about how moral rights came to be part of the U.S. copyright framework. So VARA was passed sort of following U.S. accession to the Berne Convention. And prior to that, there were no moral rights recognized in U.S. copyright law at all. The basis for U.S. copyright law is economic rights, right? Is the idea that we want to give rights, put copyrights into the hands of those who are best positioned to publish and disseminate copyrighted works to the public. So the focus in U.S. copyright law is very much on economic rights and on alienability of copyright in the interest of making sure that copyrighted works get disseminated out to the broader culture. Moral rights under EU law are much more robust, right? And EU copyright law really is centered on the person of the author in a way that U.S. copyright law is not, right? So, for example, in EU authors' rights, the focus is really on the work as a manifestation of the author's personality, right? And so you get moral rights under EU law where the artist, can control the integrity of his or her work. And you get rights of attribution under EU law that we didn't traditionally have in U.S. copyright law, at least not before Berne accession, right? So under U.S. copyright law, as I said, the focus, is more on the work as a way of promoting the progress of knowledge in the arts, which is what the Constitution tells us copyright should do. Whereas in Europe, the focus is much more on sort of protecting the author's sense of the work and the author's investment of creative energy in the work. So the U.S. adopted VARA, but because VARA was so much in tension with the sort of the economic basis of U.S. copyright law, moral rights came into U.S. law for a very, very narrow swath of works. And the rights were commensurately also narrow for that narrow swath of works, right? So one of the rights that right holders have under VARA for works of visual art is the right of integrity. And under U.S. law, the right of integrity is limited, and it protects only the physical integrity of a covered work and not its contextual integrity. Right, so Demotica wanted to use VARA and the right of integrity as a way of trying to control the meaning of his work, right? Trying to control the way other artists could interact with his work and how other artists could encourage the public to see his work. And so he was sort of attempting to use the right of integrity as a way of policing the contextual integrity of his work. But that's really not something that VARA permits him to do. And in addition, there's a presentation exception in VARA that exempts changes relating to how a work is displayed and how a work is lit. Because one of the things that that gallerists and people who operated museums worried about at the time when VARA was being considered for inclusion in the Copyright Act was whether the right of integrity, if it was too expansively defined, would really prevent them from putting together shows, right? Because it would give the artist potentially the ability to say, no, I don't want my work placed alongside the work of this other artist. And so artists and gallerists were very much worried that the introduction of the right of integrity, right, which protects against distortions and mutilations of the work, would basically inhibit the work of putting on art shows and selling works of art in retail gallery settings.
So if I understand it, then the reason Demotica wouldn't have a right of integrity claim under VARA would be because the installation of Fearless Girl didn't affect the object that Demotica created. And so as a consequence, it couldn't possibly implicate the VARA integrity right in the first place because it didn't affect the physical thing. Would it be the case that he might have had a more viable integrity claim under EU law, do you think?
Well, I think so, because, I mean, under EU law, I think under French law, for example, there is the right of integrity extends to excessive criticism of a work, right? So the work is protected from excessive criticism. And there are also, I think, provisions in EU law in some EU countries that protect contextual integrity, right? And that allow the artist greater control over the meaning of the work and that don't limit the right of integrity just to sort of physical alteration or deformation or mutilation of the work. I mean, even in U.S. law, had there been a kind of temporary physical modification, that would not have been enough to state a claim under VARA. So, for example, I think one of the examples that there is in the legislative history of VARA is that, if you put Christmas lights on a work that was displayed in the public, that would not create a right of integrity claim.
Ah, I see. So in your paper, you talk significantly about sort of the concept of the author and how the conceptualization of the nature of the work can also affect the concept of the author. And I was wondering if you could talk a little bit about that here. I mean, does this economic versus moral rights conceptualization of the sort of the way that copyright works, does it affect how people conceptualize the author as well and the relationship between the author and the work?
Well, I think it does, because when you think of copyright as something that's alienable, it becomes something immediately that is somewhat less fully identified with the person of the author, right? So the idea is that these are works that we put out into the marketplace, that we put out into the public, right, for the public's benefit, but also for the benefit of secondary authors, right, who will interact with those works and build upon those works to produce even more works. When you have a regime that is not focused on alienability and economic rights, I think that the relationship between the work and the author seems somehow much more central or inviolable. And I think that's why under EU law we have much stronger moral rights regime than we have under US law.
Well, it seems to get into the concept of intertextuality that you mention in the title and that comes up in various places in your article. What does that mean, and how is that important, the concept of intertextuality, for understanding how we think about authorship, ownership, and control of works of authorship?
Yeah, so the concept of intertextuality comes from literary theory and specifically from narrative theory, and it's basically concerned with how texts relate to and reference and interact with each other. And the two theorists on whose work I rely in the paper are M.M. Bakhtin, who's best known for a work called The Dialogic Imagination, and Gerard Genette. And both Bakhtin and Genette are sort of fundamentally interested in how authors sort of engage in dialogue with other authors, and how every individual literary work or work of art is a kind of tissue or web or fabric of multiple works, right? And just this notion that no work is really created in a vacuum, right? So Bakhtin talks about sort of the difference between monologic authorship and a monologic view of literature, and dialogic authorship or a dialogic view of literature. And monologism he associates with the genre of poetry, right, where we have this notion, and it's what we would, I think, associate with notions of, romantic authorship, that there's this poet, and the poet has some kind of unique channel for some divine inspiration. And it's this sort of individualized, highly individualized voice of the poet. And we are kind of invested in the poet's personality and the poet's unique vision. And the idea is that the poet should control how his or her work is read. And that we should be, reading the work for the purpose of trying to understand what the poet is trying to tell us about him or herself. And that's distinguished from dialogic authorship, which Bakhtin associates with the form of the novel, which is this kind of multi-voiced and multi-vocal kind of layered understanding of discourse, right? Where in the novel, you have lots of different characters who are talking to each other, and those characters have different voices, and they come from different subject positions in terms of their education and where they're situated socioeconomically in society. And so the idea is that in novels you get this kind of, you get a richer discourse, right? And a discourse that's actually populated by all of these different voices interacting with each other. So my argument in the article is basically that U.S. copyright law really is much more reflective of this kind of dialogic understanding of authorship and of the way texts operate and of the way authors make texts, whereas EU law and authors' rights law is much more monologic and more closely identified with this notion of the author as the kind of controlling consciousness in a text, right? And the person whose voice should be heard kind of on its own.
Yeah, and in your article, you use kind of the fair use doctrine in U.S. copyright law and sort of, corresponding doctrines or the lack thereof, I guess, under EU law as a way of sort of illustrating that distinction in a doctrinal sense. I was wondering if you could kind of walk us through how that works. Sort of like, how does the American doctrinal concept of fair use sort of reflect dialogic understanding as opposed to the way European law thinks of similar kinds of uses of pre-existing works of authorship?
Yeah, so the U.S. fair use doctrine is different from exceptions and limitations in the EU in that it's a much more robust and flexible doctrine. Basically what fair use doctrine says is that secondary authors can borrow from the works of primary authors without any authorization and without any compensation. for a limited range of purposes, but the analysis is a flexible one that considers the purpose and character of the use, that looks at the nature of the original work, that looks at how much of the work was borrowed, and that looks also at the effect of the borrowing on the market for the original work, right? And that notion of market harm is closely connected to the grounding of U.S. copyright law in sort of economics, right? And the idea that it's an economic right. So we're worried about depriving the author of a market for the work that the secondary author is borrowing from, right? But we're not so much worried about the fact that the original author doesn't like the use or wouldn't approve of the use, right? In fact, fair use doctrine in the U.S. is specifically structured to permit critical commentary on existing works, right? And to even permit uses where permission was sought and refused by the author of the original work, right? Whereas in the EU, exceptions and limitations are much more narrow. And there is, for example, there's a limited right to quote from existing works, or there's a limited right to parody existing works. But there's nothing as kind of open-ended and standards-based as the fair use doctrine. And I've argued that broad fair use doctrine is one of the ways that we know that U.S. copyright law is intended to promote dialogue, right? And is sort of understanding of the fact that the way culture moves forward is when works build on each other and when artists are in active dialogue with other artists who are both their contemporaries and also other artists who came before them. And I guess we should talk, too, about the derivative work right, which was the other theory that Demotica was pursuing. When he sent his demand letter to the city of New York, he alleged both that his right of integrity under VARA had been violated, but also that his derivative work right had been violated. And U.S. copyright law also places some limits on the derivative work right. For example, if there hasn't been copying of material from the original work, and there hasn't been any physical incorporation of the original work into the new work, we say that there's no violation of the derivative work right. Right, and so this was a case where neither VARA nor the derivative work right could stretch far enough to allow Demotica to exercise control over the positioning of that secondary work sort of in the physical environment of his work. And so I think that, the narrow derivative work right combined with the broad fair use doctrine, are ways that we know that U.S. copyright law really is sort of motivated and driven by this fundamentally dialogic understanding of cultural production.
Yeah, I mean, it seems like in a lot of ways with respect to the derivative work question, I mean, it really reflects how the concept of the work is defined really differently. I mean, under U.S. law, it seems, to try to be as concrete as possible about, what the work is and by extension, what the work isn't. Whereas this alternative concept of the work is much more discursive. It seems like it's about what the work means, not about what the work kind of constitutes physically.
Right. Well, it's interesting. There's a sense in which kind of the metes and bounds of the work matter. Right. And I would say they matter under U.S. copyright law, but under U.S. copyright law, the interesting thing about the nature of the copyright in the work is that copyright is kind of, I tell this to my students, copyright is unevenly distributed in any given work, right? Because every work U.S. copyright law recognizes is sort of an agglomeration of copyrightable and uncopyrightable elements, right? And so U.S. copyright law protects the work, right, as this holistic thing. right? But in reality, when it comes to, for example, determining whether somebody's work has been infringed, the instruction is that the courts require us to filter out the unprotected elements of the work, right? So that all that is left behind in theory anyway is the part of the work that is original to the author who's claiming that his or her work was infringed. And so I think also that notion that copyright is not evenly distributed is really central to U.S. copyright law. And it again reflects this idea that in any given work there is a mixture, right, of stuff that we might properly say belongs to the author, but all kinds of stuff that doesn't belong to the author, right, and that you couldn't even plausibly claim originated with the author, right? Whereas I think, in the EU, you much more get this notion of the work as something that is entirely sort of by and for the author. And I just think they're very, very different. They're different conceptions of authorship. They're different conceptions of what the copyrighted work is, and different conceptions of what it is about the copyrighted work that is in the domain of property and what's not.
Yeah, and so just to shift back to your discussion of intertextuality and the kind of monologic, dialogic distinction. I mean, it really struck me that your paper and the circumstance you describe in a lot of ways also kind of reflect certain tensions between kind of legal doctrine and the norms of different discursive communities, and how kind of the art world sits uncomfortably straddling in some ways both of the sort of ways of conceptualizing the work that you describe, insofar as artists seem often quite happy to use materials from other sources in a very dialogic fashion, but once they've created a new work, are less happy about other people engaging in the same kind of dialogic activity. And I wonder if, how we should think about that tension between what the law does and how different communities seem to think about what they want or what they think should happen or what their expectations about meaning making and use are.
It's a hard question. I mean, it's like a sort of dialogue for me, but not for thee. I mean, one would hope, I guess, that artists would be alive to the fact, right, that they stand on the shoulders of giants, and alive to the fact that their work is embedded in a cultural discourse, right, that preceded them and that will exist long after they are gone. And I'm not sure what to do about that tension, because it seems wrong-headed for an artist to act as if his or her work is completely original, right? It seems that there's no artist that would say that, and yet I do think that we now live in a world that, is kind of copyright obsessed. And I don't know if I say that just because it's sort of the tiny part of the world that I live in, right? But it does seem particularly, as the digital environment becomes more and more pervasive, and as artists feel like they have less and less control over the distribution of their works, I don't know, maybe they become less willing to sort of view themselves as embedded in dialogue with others. But I mean, there's outright piracy where you're talking about, sort of just the non-transformative reproduction and sale of somebody else's stuff, right? Which copyright law is definitely supposed to protect against. And this much more kind of productive borrowing, right? That is more piecemeal, and that is more transformative in nature. And indeed, one of the critical considerations in fair use doctrine is how transformative the new work is, right? Because we want to encourage transformations of existing works and transformative uses of existing works, but we want to discourage that kind of outright piracy. And so I am sympathetic to artists who find themselves kind of at the mercy of, online pirates in the digital environment. I am a whole lot less sympathetic, to artists who sue because there was some kind of tiny sample used in a song.
Yeah, no, that makes sense. And I also wonder whether part of it isn't a function of the sort of market distinctions between fine art and commercial art, insofar as fine art is so unusual in kind of today's reproduction economy, insofar as the work kind of collapses into the unique copy in such a way as there's like one iconic representation that stands for the meaning of the work qua the artist. Whereas when it comes to reproducible art, and in particular commercial art, right? I mean, you have a much more clearer distinction between the sort of the meaning of the work and particular copies of the work. And it's, at least anecdotally, it seems to me that, artists who work in a kind of a reproduction friendly medium seem often more open to dialogue in the form of things like, fan fiction and like kind of commentary and criticism. Whereas, at least anecdotally, again, fine artists where a work has a kind of single iconic representation seem, less open to, alternative ways of conceptualizing the meaning of what they've created.
I mean, it's interesting to think of it too in terms of the audiences for which these works are created, right? Like, fine art is really created for a very small audience in a way, right? It's the people who can afford to pay for it. Whereas art forms that are more reproducible are created for the public, right? And those artists presumably have a greater stake in having a relationship to a broader public, right? And part of the relationship that you would have to a broader public as an artist, right, is in how your fans and how the public receives your work, and also how they repurpose your work, right? And how the public engages in a dialogue with the artist that's productive of other artwork, right? Whereas it seems, that in the market for fine art, you're really looking at people who are kind of collectors, right? There's a sort of investment and collector mentality that doesn't rely on public reception and doesn't rely on any kind of relationship with the wider public. And so maybe that's a way of thinking about the distinction between the two kinds of art. I mean, it's just, it's interesting to me too to see artists kind of evolve over time in the way they think about this stuff. And I've been thinking more recently about Banksy and how Banksy seems to be transforming from this kind of street artist who had no use for copyright and didn't really think about the market for his work, sort of evolve into this person who does these kind of showy performance art things at auctions, where his work spontaneously shreds itself. And I guess artists even evolve over time and grapple with their own relationship to fame and profitability, and that might change the way they conceptualize their work, right? And the ability or the right of other people to engage with their work.
Yeah, no, that makes a lot of sense. Well, I guess in closing, Annemarie, I can't help but ask you about, famous recent developments in the Fearless Girl controversy. I was just wondering if you could briefly mention what those are and say if you think they shed any light on the previous controversy, or are they just a totally unrelated but amusing sort of new sideshow?
So I don't know. I think what you're referring to is a recent, I don't know if it was a lawsuit filed by State Street Global Advisors against Kristen Bisbal, who is the creator of Fearless Girl, because she has, I think, sold some reproductions of the work in violation of a contract that she had with State Street. And State Street also brings trademark claims, I think, in the case. And interestingly, they don't bring any copyright claims. And so it's hard to know what to say about the nature of that dispute without a copy of the contract. It really makes me want to see and better understand the circumstances under which Bisbal created that work for State Street, right? Because it seems like from what I've been able to infer about the relationship, that she was permitted to make reproductions for some purposes but not for others, and so I don't know what to say about that. It seems like maybe Kristen Bisbal is feeling a little bit of the pinch that Demotica felt, right, when he thought he wasn't getting his due as the creator of the work. And it seems that she wants more range of motion, right, and more authorial prerogative than the contract that she has with State Street gives her. Right? I mean, it can't have been. I mean, obviously, it wasn't an employee work made for hire because she wasn't their employee. It can't have been a statutory work made for hire as a commission work, because I don't think sculpture's on the list of works, is it? Like 9 kinds of works that can be statutory works made for hire. And so maybe she assigned the copyright to State Street when she created the work, or maybe they took some kind of license from her. I mean, I don't know if you have any intuitions about how that went.
No, not at all. It just seems amusing to me, in the context of this kind of monologic, dialogic point that you make, that it's like, it works both ways, and you can't have it be dialogic when it's convenient and monologic when it's convenient. You're sort of stuck with legal doctrine, looking at the nature of copyright protection in one way or the other.
Pretty much. I mean, I guess you can't have your cake and eat it too, right? You can't you can't be the one who is engaging in the unwelcome dialogue and then turn around and be the person who wants total control over your own work.
Cool. Well, thank you so much, Annemarie. It's been really fun talking to you about your paper.
Great. Thanks for having me. It's fun.
Here's the bangs for No Magazine. Came out the other day.